India Legal presents Court This Week.
Hello and welcome to Courts This Week. I am Disha Best. In this special edition, we bring you the top stories of legal proceedings from the court, from lower and subordinate courts to High Court and Supreme Court. We bring a selection of major legal proceedings which made headlines this week. In the next half an hour, we will inform and update you on all the important proceedings. So let's begin Courts This Week.
India Legal presents Court This Week.
The Supreme Court has dismissed the plea filed by GS Money and Anti-Corruption Council of India Trust seeking action against Andhra Pradesh Chief Minister Jagan Mohan Reddy for writing and publicizing a letter containing allegation against senior Supreme Court Judge Justice N.V. Ramanna. Here's a report.
The Supreme Court has dismissed the plea seeking appropriate action against Andhra Pradesh Chief Minister Jagan Mohan Reddy for making public allegations against Justice N.V. Ramanna, the second senior-most judge of the Supreme Court. A bench of justices S.K. Kaul, Dinesh Maheshwari and Rishikesh Roy observed. The petitioners have made a dual prayer. The first prayer seeks to say that a senior-most sitting judge of the High Court or the CBI should look into the scandalizing remarks made by the Chief Minister of Andhra Pradesh. The second prayer is for issuance of writ of quo warranto, and that, in view of the statements made by him, he is not entitled to hold the office of Chief Minister. The second prayer legally would be not maintainable. Insofar as the first prayer is concerned, it seems that the petitioner is himself not clear as to what he wants. The issue raised with regard to the communication between the CM of Andhra Pradesh and the CJI in public domain is already being referred to the bench which is dealing with this aspect. Though pertinent, we see no purpose in entertaining the present petition and hereby dismiss it. Two practicing advocates had moved the Supreme Court seeking action against Chief Minister of Andhra Pradesh, Y.S. Jagan Reddy, for falsely accusing second senior-most judge of the court, Justice N.V. Ramanna, of interfering with the administration of justice. The petitioner advocate G.S. Mani told the court that the scandalizing remarks by Jagan Reddy were an abuse of his constitutional office and that they attacked right at the independence of the judiciary. The petitioners further stated that Reddy has attempted to lower public confidence in the judiciary for his personal gain, as he himself is facing many number of criminal cases with the CBI and the court. On October 11, Y.S. Jagan Mohan Reddy, the Chief Minister of Andhra Pradesh, wrote a complaint to the Chief Justice of India, S.A. Bobde, claiming that some High Court judges are attempting to protect the interests of the major opposition party, Telugu Desam Party, in politically sensitive matters. On November 25, top court stayed the Andhra Pradesh High Court's gag order on media reporting and social media comments on the contents of the Amravati land scam FIR. Bureau Report.
A former ICICI Bank CEO Chanda Kochar faced a setback as the Supreme Court rejected her appeal against her sacking as the bank's chief executive and managing director. Chanda Kochar, who faces charges for alleged money laundering, had approached the top court after the Bombay High Court dismissed her petition against her sacking. Here's a report.
The Supreme Court has refused to interface with the Bombay High Court's dismissal of a plea filed by former ICICI Bank Chief Executive Officer and Managing Director Chanda Kochar against her termination in 2019. Even a senior advocate, Mukul Rohatgi, frequently urged the court to hear the matter. The bench of Justice Sanjay Kishan Kaul, Dinesh Maheshwari and Rishikesh Roy said, "We are not inclined to interfere in the impugned order. This falls within the realm of private contract between bank and employee. I am sorry, Mr. Rohatgi, we cannot interfere." Appearing for Kochar, Rohtagi urged that it was not open to ICICI Bank to virtually recall the former CEO and MD's retirement. He questioned the move to terminate Kochar on the ground that the decision was taken without the prior approval of the Reserve Bank of India. He submitted, "They have converted my resignation to termination. Whether the termination can be done without approving the resignation is a question." When Justice Kaul pointed out that the RBI granted its approval for Kochar's termination, Rohtagi countered, "The employee is not covered under 35B of the Bank Regulation Act. How can my resignation be converted to termination? The RBI had no business to do this. You decided to go out on your own, but now you are saying they are terminating you. The bank is not sacking you," the Supreme Court said. Despite Rohtagi's plea to post the matter for next week, the court ultimately declined to hear the matter. Chanda Kochar had approached the Bombay High Court challenging the termination for cause communicated to her by ICICI Bank in January last year. A committee headed by former Supreme Court Judge Justice B.N. Srikrishnan had been appointed to investigate allegations that Videocon Industries were granted loans by ICICI Bank and quid pro quo Videocon invested in New Power Renewables, the company of Deepak Kochar, Chanda Kochar's husband. The Justice Sri Krishna Committee ultimately indicated Chanda Kochar last year. In turn, the board of directors of ICICI Bank terminated her employment after considering the inquiry report. As a result, on January 30, 2019, the board informed Kochar that it decided to treat her separation from the bank as termination for cause. Later, the bank revoked Kochar's retirement benefits, her efforts to obtain existing and future entitlements. Later, the bank revoked Kochar's retirement benefits, her efforts to obtain existing and future entitlements, including unpaid amounts, stock options, medical benefits were refused. Thus, Kochar approached the Bombay High Court challenging ICICI denials of her remuneration as Managing Director and Chief Executive Officer, as well as the order of termination. In March this year, the High Court dismissed the petition filed by Kochar, noting that ICICI Bank was a private body and that the service conditions of Kochar are not governed by any state. Bureau Report.
Supreme Court heard the habeas petition filed for release of journalist Siddique Kappan. Senior advocate Kapil Sibal, appearing for the Kerala Union of Working Journalists, told the Supreme Court that the wife and daughter of Kerala journalist will be impleaded in the petition. A bench headed by Chief Justice of India then adjourned the hearing till next week. Here's a report.
The manner in which the Supreme Court took up the granted quick relief to Republic TV editor Arnab Goswami was put across during the brief but animated hearing that transpired in the Siddique Kappan detention case before Apex Court. Senior counsel Kapil Sibal, representing the petitioner Kerala Union of Working Journalists, submitted the Goswami's plea was decided by the Supreme Court, though his bail petition was pending before lower court. The top court was hearing a habeas corpus plea filed by KUWJ challenging journalist Siddique Kappan's detention by the Uttar Pradesh police. Every case is different, CJI Bobde responded. Solicitor General Tushar Mehta, representing the Uttar Pradesh government, sought an adjournment for filing a rejoinder affidavit. He also submitted prayer for adjournment, saying the case involving question of liberty. The bench, which also comprised Justice A.S. Bopanna and V. Ramasubramaniam, however, rejected Sibal's request and adjourned the matter. It will now be heard next week. Kappan, a Delhi-based journalist reporting for Malayalam news portal and also secretary of the KUWJ's Delhi unit, was arrested along with 3 others in Mathura, Uttar Pradesh in October while on his way to Hathras to cover the gang rape and murder case of 19-year-old Dalit girl. They were later booked under provisions of Unlawful Activities Act and also slapped with charges of sedition. KUWJ, in a rejoinder affidavit, had told the Supreme Court that Siddique Kappan was beaten with lathi and slapped in Mathura jail. The Uttar Pradesh government had earlier told the Supreme Court that Kapans was the office secretary of Popular Front of India and that he was travelling to Hathras with other members of the PFI with the aim of creating a caste divide and law and order issue. The state government had also stated that Kapan was arrested with 4 others on October 5 and the bail application filed by the journalist and 3 others were rejected by contempt court with detailed reasons. Bureau Report.
The Supreme Court has dismissed the interim plea of mining major Vedanta Limited seeking permission to inspect its Sterlite copper unit at Tuticorin in Tamil Nadu, which is closed since May 2008 over pollution concern and to operate it for 4 weeks to assess the pollution level. Here a report.
The Supreme Court refused to grant interim relief to Vedanta Sterlite, declining the mining giant's plea for immediate reopening of its copper plant at Thoothukudi. A 3-judge bench headed by Justice Rohinton Falli-Nariman posted the case for detailed hearing in January 2001. Vedanta, in its plea before the Supreme Court, has challenged an August 2020 decision of the Maharashtra High Court rejecting the request to reopen the copper smelter plant. Vedanta's Sterlite copper plant in Thoothukudi was shut down by the Tamil Nadu State Pollution Control Board in 2018. Citing violation of environmental law, the closure order was passed immediately after the plant had turned into protest site, with citizens opposing the expansion of the plant. The order was supported by the state government, which endorsed the same within a week. The protest took a violent turn on its 100th day when police opened fire on the protester, leading to several civilian casualties. Vedanta subsequently challenged the closure order before the National Green Tribunal, which ruled in the company's favor. The order was challenged by the TNPCB before the Supreme Court in January 2019, when the court stated that the entity order of reopening of the plant will continue to operate during the pendency of the appeal. The Supreme Court in February 2019 set aside the NGT order allowing the reopening of the Sterlite plant on the ground that the NGT did not have the jurisdiction to entertain the case. However, Vedanta was allowed to move the High Court against the order passed against it. The High Court then rejected the plea, promoting the present appeal before the Supreme Court. Bureau Report.
2 petitions have been filed in the Supreme Court challenging the Uttar Pradesh and Uttarakhand anti-conversion law. Regarding the law, the plea states that it is against the basic structure of the constitution. Plea holds that the parliament or legislature can't bring about changes in fundamental right. A report. Two petitions have been filed in the Supreme Court challenging the constitutionality of the recently promulgated Uttar Pradesh Prohibition of Unlawful Conversion of Religion Ordinance 2020 and the Uttarakhand Freedom of Religion Act 2018. The petitions claim the laws made in the name of love jihad be declared null and void because it disturbed the basic structure of the constitution. The first petition filed by Advocate Neeraj Shukla said the law passed by the Uttar Pradesh government, which recommended 1 to 5 years of jail if any accused failed to prove the conversion of the woman was not for marriage, has resulted in the violation of Article 14, 15, 21 and 25 of the Indian Constitution. Right to live with a person of his or her choice, irrespective of religion, is intrinsic to right to life and personal liberty. Interference in a personal relationship would constitute serious encroachment into the right to freedom of choice of the two individuals. The petitioner has submitted that the true danger with the new so-called love jihad law lies not in the explicit textual basis, which seems fairly innocuous prima facie. Instead, its threat lies in its ambiguity. Although the scope has been cleverly restricted within constitutional margins, the law employs the use of open-textured phrases such as undue influence, allurement and coercion. The petitioner has thus asked for a direction in the nature of mandamus to the state government of Uttar Pradesh to declare the new law null and void and instead direct the central government to pass any legislation on religious conversion or enact a new law on freedom of religion and conscience. The other petition has been filed by advocates Vishal Thackeray, Abhay Yadav and Pranvesh, a law researcher seeking a direction to declare the ordinances of the two states to be ultra-vires and direct authorities not to give effect to the ordinances passed by the government concerned. The petitioner have submitted that the ordinance passed by the state governments of Uttar Pradesh and Uttarakhand is against the provision of the Special Marriage Act 1954. Bureau Report. The Karnataka High Court has issued notice on a petition which challenged the government decision to drop criminal prosecution in 61 cases against elected representatives and ministers. The High Court has sought government response in challenge to withdrawal of 61 cases against MLAs. The court said that public prosecutor cannot act like post box. Here's a report.
The Karnataka High Court has issued notice on a petition which challenged the government decision to drop criminal prosecution in 61 cases against elected representatives and ministers. A division bench comprising Chief Justice Abhay S. Oka and Justice Vishwajit Shetty observed, no court is bound by such a decision taken to withdraw from the prosecution, even if an application is made under Section 321 of the CRPC. The courts are duty-bound to assess whether a prima facie case is made out or not, and that the court has power to reject the prayer. The court was considering a petition filed by People Union of Civil Liberties Karnataka challenging the August 31 order wherein the government has granted permission for the withdrawal of prosecution of the 61 cases under the Section 321 of the Code of Criminal Procedure. The cases being withdrawn include the cases against the State's Law Minister J.C. Madhuswamy, Tourism Minister C.T. Ravi and Agriculture Minister V.C. Patil. Case from 2017 against Horsepete MLA Anand Singh is also sought to be withdrawn. Advocate Clifton D. Rosario, appearing for the petitioners, argued that the decision was against the rule of law. The court refused to stay the decision. However, it referred to the Supreme Court order in the case of S.K. Shukla and others versus State of Uttar Pradesh and others, which held that even if government instructs to the public prosecutor to withdraw from the prosecution of a case, the latter, after applying his mind to the facts of the case, may either agree with the instructions and file a petition before the court stating grounds of withdrawal, or disagree therewith, having found a good case for prosecution, and refuse to file the withdrawal petition. The decision also observed that in the event the public prosecutor disagrees, he will have to return the brief. It further observed that the public prosecutor cannot act like a postbox or act on the dictates of the state government, and he has to act objectively as he is also an officer of the court. The court said that the public prosecutor should invite the attention of concerned court to the observations of the High Court when making application under Section 321 of the CRPC. Bureau Report.
A public interest litigation petition has been filed in the Supreme Court seeking immediate removal of farmers who are protesting against the recently passed Farm Act from the Delhi-NCR border. The petition states that it is necessary to remove the gathering as the protest is posing hurdles for accessing emergency medical services needed to curb the spread of COVID-19 and to attend the patient in need of the medical attention. The plea further states that life of lakh of people protesting at Delhi border is at immediate threat since the virus is very contagious, and if by chance this coronavirus disease takes the shape of community spread, it will cause a havoc in the country. Plea states that road have been blocked by the protester, which has affected vehicular traffic, and people who are travelling to and from Delhi to get medical treatment in reputed government or private hospitals situated in Delhi are also affected. The bail plea of RJD President Lalu Prasad Yadav, who is serving a sentence in fodder scam case, was heard in the Jharkhand High Court on Friday. During this time, the court called for a reply from the Jharkhand government about the special facility and exemption given to Lalu Prasad during the sentence. The court asked the state government that by whose order the RJD Supremo was shifted from the paying ward of RIMS to the bungalow of the director of RIMS, and later on, now by whose order has it been brought back to the paying ward. Well, that's all in courts this week. Thank you for tuning in. Keep watching APN.
India Legal presents Court This Week.